this topic, yeah, for the lecture. I haven't done so with KLB2. Just bear with me. I'm just going to go through again the slides that I have presented. Okay, if you have questions, you can ask. This is also related to your case review. Yeah. So it's on professional misconduct and disciplinary proceedings. Yeah. So we're going to look at the liabilities of advocates and solicitors, the scope of the professional misconduct, disciplinary bodies that are involved, the proceedings and punishment, common complaints and cases. This one will be okay in the presentation sessions with you all, the last component. Yeah. So when we talk about liabilities of advocates and solicitors, we can actually broadly look at three perspectives. Yeah. First is criminal liabilities, and second is breach of written rules, all right, which refer to the LPA itself and the rules and rulings that are made thereunder. And the third one is tortious or contractual liabilities, which may also result in suits against the concerned advocates and solicitors. Yeah. So for criminal liabilities and breach of written rules, these are the two areas in which disciplinary proceedings may arise. Okay, for criminal liabilities, they may involve dishonesty and fraudulent conduct such as cheating and CBT or criminal breach of trust. All right. You may refer to section 94.3 as to the penalties and punishment, and 94.2 as for the serious cases that involve suspension from practice or striking off of the role by the disciplinary board. If you have time, you can flip to the respective provisions, section 94 and 94.2 and 3. Okay. So if you look at 2, any advocate and solicitor who has been guilty of any misconduct shall be liable to one or more of the following penalties or punishments. First, to be struck off the roll. Second, to be suspended from practice for any period not exceeding 5 years. Third, to be ordered to pay a fine not exceeding 50,000 ringgit. And D, to be reprimanded or censured. So if you go by the order of the gravity of the punishments, I think the first one will be the most serious one. Okay, the heaviest punishment is to be struck off the roll. Tidak boleh practice lagi. Second is suspension. Third is bayar denda, and yang akhir is menerima amaran. Ya. So kalau tengok 3, 94.3, misconduct means, okay, 94.3 is misconduct means conduct or omission by an advocate and solicitor in their professional capacity or otherwise. Personal capacity can also amount to grave impropriety and they shall include. Okay, 94.3 should be, silap sikit ni ya, 94.3 should be okay, 94.3 should be the I think meaning of misconduct, right? Okay, meaning of misconduct 94.3, right? So please excuse me for this error. Meaning of misconduct is section 94.3. 94.2 is the punishments or penalties. Alright, okay, if you look at section 88A and section 94 clause 4, alright, they actually concerned with the power of Bar Council to lodge complaints at disciplinary board and to intervene. Alright, section 88A, if you can go to that section and have a look at 88A. Okay, this is the case of suspension of advocate and solicitor who has been found guilty by court of any offence involving dishonesty or has been disbarred or suspended or censured in respect of whom complaint has been made. Ya. Baca A sampai E, okay. These are the situations in which the Bar Council may consider to intervene if it is in the public interest to do so. Okay, so in order to intervene, the Bar Council has to apply by summons ex parte to the Chief Justice for an order to suspend such advocate and solicitor from practice until further order. So this is the role of the Bar Council in the case of suspension. Yeah? So this is how it is done. Yeah? All right. What about section 94 plus 4? 94 plus 4. Okay, this is also the same situation. Okay. This is also the same situation. Yeah. Section 94 plus 4. Yes. Ya, ada soalan?
Madam,
Ya.
suspension ni permanent ataupun temporary?
Suspension berbentuk temporary. Kalau you tengok tadi, 94 clause 2 clause B to be suspended from practice for any period not exceeding 5 years. Please, can you switch off the mic first? Tak dengar. You switch off the mic first, tak berapa dengar tu ya, pecah-pecah ya. So 94 clause 2 clause B, you tengok suspension from practice must is for a period that is not exceeding 5 years, tak lebih 5 tahun. Kalau tak boleh practice terus, kita panggil struck off the role. Alright, suspension ni digantung daripada practice untuk tempoh masa yang tertentu ya. Okay. Kalau kita tengok 88A, it is concerned with guilty advocate and solicitor in respect of control of property. Alright, control of property masuk bawah section 88. Kalau section 94 tadi adalah 94 and then the provision that allows for intervention by the Bar Council to apply for suspension is under 94 clause 4. That one is for other misconduct as defined in section 94 clause 3. So please have a look through. Okay, the compensation fund. Okay, we have the I think the rules on the establishment of the compensation fund as well as for professional indemnity insurance. These are all to ensure mitigation of losses to the public in the case in cases where advocate and solicitor has been found guilty of a certain misconduct and it has caused losses and damages to the clients. All right. So Bar Council has actually manage this compensation fund in order to mitigate losses to the public. Yeah, professional indemnity insurance is also under one of the rules. This is to mitigate losses on the part of the advocate and solicitors, right? So if you talk about tort and contract, they are quite interrelated. But for tort, normally we would require the proof of fiduciary relationship to firstly be established. All right. If it goes to the court, then the court needs to ensure that there is evidence of fiduciary relationship. And if it is especially for breach of duty of care and fiduciary duty. But for breach of contract, then contractual relationship needs to be proven as well. This can actually be derived from the retainer. Okay, the written normally the written contract between the client and his or her advocate and solicitor. Alright, and this one can also be implied retainer ni tak semestinya bertulis secara formal, can also be implied by conduct and acquiescence. Okay, and breach of duty of contract in the case of contract that falls within the scope of the retainer can also invoke suits by the clients. Yeah. Right. So if you look at section 94, 3A, 3 clause A up to E, these are the kinds of acts that can amount to misconduct that are quite broad ranging. Yeah. Okay, comprising dishonesty, okay, breach of LPA rules or rulings, conviction of a serious offence, misappropriation of money or monetary dishonesty, charging excessive fees, inordinate delay, breach of stakeholders' duty, unbefitting conduct, gross disregard of clients' interests. So these are the categories of misconduct as we can identify from section 94. Yeah? Section 92 to section 11 is section 92 to section 111 mainly address misconduct and disciplinary proceeding lah, yeah. So breach of stakeholders duty, this is an example of a case study lah, yeah. So as a solicitor who acts for two or more parties, they must adhere to the terms of the stakeholding. This is relevant in the case where a solicitor is acting for two parties, such as for a purchaser and also for a financial, okay, in a sale and purchase agreement, for instance, yeah. So no money or document held by solicitor shall be released, right? Utilized, applied, or otherwise dealt, okay, except in accordance with the terms of the stakeholding or with the express written consent of all relevant parties. Remember, before this, we did discuss on the what was the document called that we discussed in the tutorial before? Letter of, is it letter of guarantee or something?
Letter of acknowledgement, madam.
Letter of acknowledgement. Okay, it's also part of the the terms of the stakeholding. Yeah. So you have to declare that you are acting for which party, right? So this is part of the terms of the stakeholding, right? So for example, in the case of a solicitor holding the final 5% of the purchase price, okay, for the sale and purchase agreement under the Housing Development Control and Licensing Regulations, okay, he or she must not release the same before the expiry of the stakeholding period or in contravention of Schedule G. So this is the terms of this. These are the terms of the stakeholding contained in Schedule G, as well as Schedule F as the case may be. So kalau you breach this one, you may be liable for a misconduct. Okay, may be tried by the board. Yeah. So you have the disciplinary board and the disciplinary committee established under section 93 and 96. Okay, we tengok. So disciplinary board under 99 clause 3 is a body entrusted to conduct disciplinary proceeding against advocate and solicitors. Betul ke 99 clause 3? 99 clause. I don't think this is correct. No, it's 93 clause 3, not 99. Banyak error. 93 clause, check balik. 93 clause 3 talks about the disciplinary board. Alright. 93 saja. 93 ya. Alright, kalau you tengok dia punya membership, it's under 93 clause 3. You have the chairman of the disciplinary board appointed by the Chief Justice after consultation with the Bar Council. And such person shall be a retired judge of the High Court or the Court of Appeal. Yeah? And then you have also the president of the Malaysian Bar or any member of the Bar Council as his representative. And then C, you have 15 practitioner members of the Malaysian Bar of not less than 10 years standing appointed by the Chief Justice. So the terms are normally for 2 years for these people. So the quorum of the disciplinary board, you tengok under subsection 4, it shall be 7 members, alright, from paragraph 3A tadi, 1 member from 3B, 5 members from 3C. 3C tu practitioners, right? Okay, itu semua adalah mengenai disciplinary board. Okay, so if you ask whether disciplinary board and bar council are one, one body, they are actually separated. They are independent of each other. Okay. This is to ensure transparency and accountability. We want to avoid perceived bias in the conduct and decisions of the tribunal. Yeah. So Bar Council does not exercise any right or control over the investigation process. Right, so jadi kita dah tengok the membership. Alright. Disciplinary committee, you can look at section 103A2. It has 3 members, 2 of whom shall be legally qualified and 1 lay member. So what is the role of the disciplinary committee? It is actually to conduct a full inquiry by perusing the relevant documentary evidence. Okay, and in the presence of the complainant and the advocate and the solicitor concerned, and by summoning the attendance of witnesses. So they are going to conduct the hearing, yeah, to arrive at an appropriate finding on liability. Okay. So is the disciplinary board bound to concur with the findings or recommendations of the DC? Okay, DC or disciplinary committee can make recommendation and findings of their hearing to the disciplinary board. Disciplinary board may concur, agree, may enhance or dismiss the complaint as it deems fit. So disciplinary board is more powerful than this committee lah. Ya. Okay. Cuba tengok dia punya scope of or jurisdiction of each of these bodies. Ya. Alright. So if you look at 100, yeah, inquiry into application of complaint, section 100, okay, where a written application or complaint is made or referred to the disciplinary board, okay, disciplinary board, if it is satisfied that there is no merit in the application or complaint, dismiss the application or complaint. If there is merit in the application or in the complaint, disciplinary board shall post or deliver to the advocate and solicitor a copy of the application of complaint, okay, and request the advocate and solicitor to furnish written explanation together with supporting document within 14 days of the request. So the first step is to require the advocate and solicitor to submit his written explanation, and this shall be reviewed by the disciplinary board within the required time frame. Section 103, Clause A, 103A, appointment of disciplinary committee, yeah, where the disciplinary board determines that a disciplinary committee ought to be appointed. Okay, B, an advocate and a solicitor has been convicted of an offence of criminal breach of trust, and C, the advocate and solicitor has been suspended under Section 94, Clause 4 tadi. Okay, then the disciplinary board, as soon as may be practicable, appoint a disciplinary committee, okay, consisting of 2 advocates and solicitors and 1 layperson to make an inquiry, further inquiry, into the written application of complaint and to make its findings. So in very specific situations, all right, so you look at section 9.
Doctor,
Yes.
I have questions. What is the significance of having one lay person in the disciplinary committee panel?
One day person appointed from the disciplinary committee panel. This one is, if you look at the nature of the situations that warrant for the appointment of disciplinary committee. First is CBT, ataupun in a situation that disciplinary board determines that this committee ought to be appointed. C, suspension. Layperson ni, other than here, where else is it mentioned? So I think it represents public interest though. When you talk about public interest, you need to have someone outside the legal profession. If you see the disciplinary board's composition just now, they consist of people from the judiciary and from the profession, bar counsel, people from the bar and people from the judiciary. But when it concerns with the appointment of disciplinary committee, right? this lay person is appointed. Okay, I don't have a direct answer to this, but I believe that it is inserted to represent the interest of the public. All right, but one lay person, I think if you go deeper into the guidelines by the Bar Council beyond what is provided in the LPA, I think there are certain criteria that this lay person has to also meet. It's just not any Tom, Dick and Harry lah. Mesti ada some criteria for this lay person to be appointed. Kalau tak ada dalam ni, mesti ada dalam guidelines ya. Right.
Okay, Doctor. Thank you.
Madam,
Yes.
kalau layperson ni dia just ambil opinion je lah, dia bukannya dalam dia tak boleh jadi decisive punya entity untuk deliver decision kan. Dia ambil dia beri opinion kepada DC sahajalah, ke dia boleh menentukan juga?
Dia macam you have to refer kepada purpose of appointment tadi. Alright, and then kalau balik semula kepada slide ni, kalau you tengok ya, no sorry, slide this one. Okay. So it can only, the role of this committee is to to hear documentary evidence, to look through the documentary evidence and also to summon the attendance of witnesses, okay, and to arrive at an appropriate finding or liability or otherwise, as the case may be, and make recommendations to the disciplinary board in the specific situations outlined in section 103A. Okay. Tengok 103A. Dalam specific situation tersebut, DC, disciplinary committee, may be established, and the role is as what I mentioned, and they have to arrive at an appropriate finding and also recommendation to the SDB. ASDB ni, Advocate and Solicitors Disciplinary Board. But the board may not necessarily concur with their findings or recommendations lah. Yeah. So you boleh tengok dulu section 103 sub 103B, the process of inquiry by the disciplinary committee. Yeah. So they may be asked to, the advocate and solicitor may be asked to present documentary evidence such as book, document or paper, and also may be summoned, other person may be summoned to give oral evidence. Okay. Okay, kalau you tengok 103C, baca lagi ya, kalau you nak faham. The recommendations, alright, that they can make, okay, among others, you look at A, that no cause for disciplinary action exists and that the application of complaint be dismissed, right? So, bila ada satu komplain mengenai isu-isu yang disenaraikan di bawah section 103A, right, ataupun dalam discretion disciplinary board, this disciplinary committee ought to be appointed, maka boleh mereka appoint ya this disciplinary committee, right? Tugasnya seperti yang beritahu tadi, dan findingnya adalah awak boleh tengok 103C ya, sama ada terdapat cause for disciplinary action. Cause ni maksudnya you ada merit tak untuk proceed untuk hearing proper ya, with the board. that cause for disciplinary action exists but is not of sufficient gravity to warrant any punishment other than a reprimand or censure. Okay. C, that cause for disciplinary action exists and is of sufficient gravity to warrant the following penalties. Dia boleh cadangkan penalti sekali, and also striking the advocate pun dia boleh cadangkan juga. Okay. Alright, itu adalah kuasa disciplinary committee. Alright.
So maknanya madam, apa yang saya faham lah, correct me if I'm wrong, dia akan investigate by DC dulu, and then kemudian DB yang akan decide sama ada recommendation tu terima ataupun ditambahkan ataupun dikurangkan. So maknanya yang konklusif tu dekat DB lah.
Ya, ya.
Oh,
Tapi whether or not to appoint the disciplinary committee is up to the disciplinary board to determine, ya. Kalau you tengok A, it's very general. B tu memang dia kena appoint. Kalau you tengok 103A bawah 1B, an advocate and solicitor has been convicted of an offence of CBT under section 409, very specific. Ataupun convicted of any other offence involving fraud or dishonesty. Yang ni memang dia kena set up DC ni. Alright? Ataupun apabila advocate and solicitor has been suspended under subsection 94 clause 4 tadi. Okay, by virtue of intervention of bar counsel, okay, to apply for suspension. Right? Itu adalah prosedur. Dalam presentation you nanti, minta tolong highlight juga you punya diagram of the process. Saya ada minta you buat, tapi saya tak tulis rasa. Other than the cases, satu kumpulan, satu TLB, satu case cukup lah. And then briefly on the diagram saja, tak perlu detail macam infografik saja. Alright. So section 94 clause 2, they may be liable for one of these punishments lah. Okay, kita dah bagi tahu tadi ya. Suspension you tanya tadi sama ada permanent, dia tidak boleh lebih daripada 5 tahun. Lepas tu dia boleh apply untuk be reinstituted as an advocate and solicitor lah. Okay, kalau to be struck off ni, then you cannot practice anymore lah. Macam kena, orang kata macam penjara seumur hidup lah, macam habis lah kalau you kena struck off ya. Very serious offence. So how does ASDB disciplinary board deal with a complaint? First, they will deliberate on the complaint whether there is merit on the issues or not. Second, if merit is established, okay, direct that a DC be constituted to conduct a formal inquiry or issue a notice to the solicitor to appear to tender an explanation before the board. Okay, so you boleh ada dua pilihan di sini ya. Untuk ASDB, they can have these two routes ya. Sama ada they require that the disciplinary committee be instituted immediately, or they firstly issue a notice requiring explanation by the alleged or by the complaint solicitor, advocate and solicitor. And so if there is no merit, they will dismiss the complaint without a formal hearing. Itu basically adalah secara ringkas sajalah. Detail dia nanti adalah based on, I think mesti ada dekat bar counsel ataupun mana-mana. Dia punya detail SOP ya. Is there an avenue to appeal against the decision of the disciplinary board? Yes. Okay, you may lodge an appeal to the High Court against the decision within 1 month from the date of notification of the order. Boleh appeal to the High Court. Is there a need to be represented by counsel at the disciplinary hearing? Generally, dia kena defend diri sendiri unless in the specific areas he is not well versed with. Okay, he's not well versed in, dan dia boleh lantik lah. Dia boleh request lah untuk to be represented by an advocate and solicitor. Generally tak lah. Okay. Nantilah. Alright. Apa lagi? Okay, each TLB to present common complaints and just one lah ya. Nanti kita tak sempat nak discuss. One recent case. Okay, one recent case. Common complaint ni dalam bentuk senarai je, okay? List. Alright, common complaint, one recent case. And a diagram. A diagram of the SOP lah, okay? For hearing with the okay, from the complaint stage until the stage of decision. Okay, untuk yang diagram ni, 1 KLB 1 diagram. Cukup lah. Tengok broad saja. Okay, faham kan? Ataupun list ni pun 1 KLB 1 list. Okay. Common complaint. Each KLB. Okay. Each TLB to present one recent case. Okay. Saya nak simplify aja, tak payah pening-pening. Each KLB to present a list lah. A list of common complaints and a diagram of the SOP from the complaint stage until the stage of pronouncement of the decision. Okay. Next. Okay. Each. Boleh? Faham ya? Simple je. Are you okay with this task? Are you okay? Okay.
Madam.
Ada soalan lain tak lagi?
Sekejap madam, maknanya tadi tu list tu ikut TLB, lepas tu nanti gabungkan bawah kuliah lah. Macam tu ke madam?
You masa kita boleh juga masa kita buat tutorial nanti yang join tutorial, 1 jam saya buat dengan KLB 1, 1 jam lagi saya buat dengan KLB 2 kan? Saya buat 2 jam, 1 jam dengan TLB 1 until 4, 1 jam lagi TLB 5 until 8. Masa you present nanti, you just tunjukkan diagram tu satu saja untuk satu KLB lah. Lepas apa dia?
Sorry. I was interrupting. Sama Madam cakap nanti saya tanya.
List tu pun satu je. Tak payah banyak lah. And then case yang recent saya nak tengok lah kalau ada appeal daripada High Court ke. I don't think section of the disciplinary board is accessible, tapi you boleh check kod-kod Bar Council ada keluarkan secara dia publicize decision of the board. Saya tak pasti yang ni.
Madam, dia punya komplain tu tak boleh sama ke atau apa?
Kalau boleh, apa yang you research lah. Tak payahlah gantung pada, you buat lah apa yang you, based on your findings lah. Mungkin sama sebab you punya research sendiri kan.
Okay madam, thank you madam.
Alright, saya rasa itu saja. Saya nak pergi USIM, ada meeting. Kalau tak ada apa-apa, saya update nanti. Tolong update whether you are able to do the joint tutorials on this Friday.
Madam, saya ada satu lagi soalan.
Yeah.
So basically apa yang saya nampak lah, disciplinary committee tu yang ada layperson tu, layperson ni dia punya kuasa tu dia tak adalah konklusif, dia buat investigation sajalah.
Ya.
Dengan sama
Dia
dengan
recommendation. Dia buat recommendation sama ada merit atau tidak kes tu. Lepas tu tadi ada course of action, kemudian dia boleh buat finding sama ada guilty atau tak, and dia boleh buat finding apa bentuk punishment. Dia boleh buat recommendation, dia present recommendation tu kepada disciplinary board. Disciplinary board akan tentukan dia nak agree ke tak dengan finding ataupun dia mungkin ada dapatan yang lain. Faham? They're not bound to not bound by the recommendations given by the disciplinary committee. Okay?
Maksudkan madam, kalau sebabkan dia kan layperson kan, dia tak ada legal background kan.
Yang tu saya tak boleh nak cakap secara konklusif sebab mesti dia ada kriteria layperson yang macam mana boleh duduk dalam board tu, dalam komiti tu. I don't think just any Tom, Dick and Harry. Saya cakap you kena research dekat Bar Council punya website. Normally dia orang ada kriteria dia. Masa you buat diagram SOP tu mungkin you boleh highlight. Siapa layperson ni, takkanlah Pak Cik Ahmad yang tak siapa-siapa you jemput kan. Mesti ada kriteria. By common sense mesti ada kriteria lah. Okay, ada lagi tak soalan?
Okay, thank you madam.
Okay, kalau tak ada nanti kita jumpa lagi ya. And please update me. I think that's all for today. I've downloaded the attendance ya. Right, thank you. Assalamualaikum ya.
Alright, thank you doktor.